Question number 601. For setting aside an ex parte decree under CPC, Order 9, the affected party needs to file a review petition, an application, a fresh suit, a revision. Correct answer here is option B, that is an application. For setting aside an ex parte decree under CPC, Order 9, affected party needs to file an application. Question number 602. In a suit for partition, 3 defendants were set ex parte. Preliminary decree was passed. On the application of one of the 3 defendants, the court set aside a decree as against all the defendants. The order of the court is legal, irregular, unjustified, illegal. Correct answer here is option A, that is legal. Question number 603. Where the appellant has withdrawn the appeal preferred against a decree passed ex parte, the application under Order 9 Rule 13 of CPC shall be rejected, returned, maintainable, referred for the opinion of the appellate court. Correct answer here is option C, that is maintainable. Question number 604. Remedies available against an ex parte decree include appeal, review, application for setting aside the decree, all of these. Correct answer here is option D, that is all of these. Remedies available against an ex parte decree include appeal, review, application for setting aside the decree. Question number 605. Even after ex parte proceedings, the defendant can take part in further proceedings of the suit. This principle was pronounced by the Honorable Supreme Court in the case of option A, State of Bombay versus United Motors, option B, State of Rajasthan versus Vidyavati, option C, Vijay versus R.N. Gupta Education Society, D, Arjun Singh versus Mohinder Kumar. Here in question number 605, correct answer is option D, that is Arjun Singh versus Mohinder Kumar. Question number 606. Which of the following remedies may be sought against ex parte decree? Option A, only application under Order 9 Rule 13 CPC, only an appeal under Section 96 Clause 2 of CPC, both A and B, and option D, none of these. Here correct answer is option C, that is both A and B. And Order 9 Rule 13 of CPC and appeal under Section 96 Clause 2 of CPC. Question number 607. A civil suit was repeatedly fixed by the trial court for examination of the defendant's witness, but the said opportunity was not availed by the defendant. Therefore, on 18th November 2016, when neither the defendant nor his counsel had appeared, the trial court had proceeded ex parte and heard the final arguments and reserved the case for the judgment. On 28th November 2016, the defendant had filed an application under Order 9 Rule 7 read with Section 151 of the CPC, which is maintainable, not maintainable, matter of discretion of the court to accept or not, matter of inherent power of the court to accept or not. Here correct answer is option B, that is not maintainable. Question number 608. When an ex parte decree is passed, the defendant can file an appeal under Section 96 of the Code of Civil Procedure, can file an application under Order 9 Rule 13 of the CPC to opt either A or B. It is an application B above is dismissed, can file appeal to dispute the correctness of the order passed. Here correct answer is option C, that is either A and B. When an ex parte decree is passed, the defendant can file appeal under Section 96 of the CPC and can file an application under Order 9 Rule 13 of the CPC. Question number 609. An ex parte decree can be set aside on the ground that summons were not duly served, non-appearance of the defendant as copies of the documents filed with plaintiff were not provided by the defendant, defendant refused to receive the summons and thereafter no fresh summons were issued to him. An ex parte decree cannot be set aside under any circumstances. Here in question number 609, correct answer is option A, that is summons were not duly served. An ex parte decree can be set aside on the ground that summons were not duly served. Question number 610. When an ex parte decree is passed, the defendant would normally ask for setting aside an ex parte decree by an application under Order 9 Rule 13 of CPC, by filing a revision petition under Section 115 of the CPC, by filing a petition under Article 227 of the Constitution of India, by filing an application under Order 9 Rule 7 of the CPC. Here correct answer is option A, by an application under Order 9 Rule 13 of the CPC. Question number 611. Under which of the following provisions of the CPC an ex parte order and an ex parte decree may be set aside? Correct answer here is option C, that is Order 9 Rule 7 and Order 9 Rule 13. Question number 612. Mark the incorrect statement. Option first. In deciding the restoration of application for setting aside an ex parte decree, the merits of the case should be taken into account. B. As a general rule, the court will set aside the decree only against such defendant or defendants who has made an application. C. Where the decree is of such nature that it cannot be set aside against such defendant only, the court may set it aside against the other defendants also. No ex parte decree cannot be set aside without notice to the opposite party. Here in this question it has been asked which of the following is incorrect. Option A is an incorrect. Therefore, it will be the right answer. Question number 613. A suit may be dismissed under Order 9 of the CPC, where the summons is not served upon the defendant in consequence of the plaintiff's failure to pay cost for the service of summons, where neither the plaintiff nor the defendant appears, where the plaintiff, after summons returned unserved, fails for 7 days to apply for the fresh summons, where on the date fixed for hearing in a suit only defendant appears and he does not admit the plaintiff claim. Here correct answer is, in question number 613, is option D, that is all of the above. Question number 614. When an appeal against a decree passed ex parte has been disposed of on a ground that other than withdrawal by the appellant, then application for setting aside the ex parte decree is, option C is the correct answer, that is not maintainable. Question number 615. After being proceeded against ex parte, the defendant is precluded absolutely for participating in any proceeding in the suit, at liberty to join the proceedings at the stage where the proceedings are pending, at liberty to join the proceedings and do all things which it would have done had he not been proceeded against ex parte without getting ex parte order set aside, none of the above. In question number 615, correct answer is option B, at liberty to join the proceedings at the stage where the proceedings are pending. Question number 616. In a suit for recovery instituted by A against B, despite the summons suit have been duly served upon B, he did not appear on the date fixed on the summon on 1/3/1993. The court consequently on 1/3/1993 passed an ex parte order against B and listed the case on 3/4/93 for ex parte evidence of A. Here options are, B can participate in the further proceedings of the case. Option B can seek setting aside of ex parte order if he is able to show good cause of his appearance. C, both A and B are correct, and D, both A and B are incorrect. Here correct answer is option C, that is both A and B are correct. Question number 617. A suit may be dismissed where summons are not served on the defendant in consequence of the failure of the plaintiff to take proper steps like filing of court fee, postal charges or requisite number of the copies of plaint. B, neither party appears where the suit is called on for hearing. C, plaintiff after summons to defendant has returned unserved, fails to apply for fresh summons for 7 days. And D, all of these. Here correct answer is option D, that is all of these. In all of these cases, suit will be dismissed. Question number 618. Court can direct the parties to opt for any one mode of alternative dispute resolution under CPC in. Here correct answer is option A, that is Order 10 Rule 1A of CPC. Question number 619. Can a civil court examine party at first hearing? Options are no. Option B, court can examine party till evidence has been recorded. C, court should not examine the parties opposed party had right to cross-examine. And D, yes. Here correct answer is option D, that is yes. Question number 620. Under CPC at first hearing the suit, the court must frame and record issues, record the evidence of the plaintiff, ascertain whether the allegation in the pleadings are admitted or denied, all of the above. Here correct answer is option C, that is ascertain whether the allegation in the pleadings are admitted or denied. Question number 621. Which of the propositions is incorrect with regard to oral examination of a party by the court under Order 10 Rule 2 of CPC? Options are, the examination need not to be restricted to the allegation in the pleadings of the party but can relate to elucidating any matter in controversy in the suit. The court can examine not only the parties but any person accompanying either party to the suit. C, the statement made during the course of the examination is not an oath. And D, the court can cross-examine any of the parties with reference to document. In question number 621, correct answer is option D, that is the court can cross-examine any of the parties with reference to document. Question number 622. The court at the first hearing of the suit can only frame issues, may permit cross-examination of either party by the other to elucidate the matters in controversy in the suit, may examine either of the parties, none of these. Here correct answer is option C. The court at the first hearing of the suit can elucidate the matters in controversy in the suit and may examine either of the parties. Question number 623. The object of oral examination under Order 10 Rule 2 of CPC is. Here correct answer is option A, to elucidate the matters in controversy in the suit. Question number 624. A party under CPC may object to answer in interrogatory if it is scandalous and irrelevant, malified and immaterial, privileged, all of these. Here correct answer is option D, that is all of these. Question number 625. Any objection of interrogatories may be taken on the ground that it is irrelevant, scandalous, non-exhibited, bona fide, all or any of those. Here correct answer is option D, that is all or any of those. Question number 626. Interrogatories shall be answered as provided under Order 11 Rule 8 of CPC on a simple application, on an affidavit, by filing the documents, all of the above. Here correct answer is option B, that is on an affidavit. Question number 627. The consequences of non-compliance with the order to answer interrogatories or for discovery or inspection of documents have been dealt with under. Here options are Order 11 Rule 12 of the CPC, Order 12 Rule 21 of CPC, Order 11 Rule 21 of CPC, Order 12 Rule 21 of the CPC. Correct answer here is option C, that is Order 11 Rule 21 of the CPC. The consequence of non-compliance with the order to answer interrogatories for the discovery or inspection of documents have been dealt under Order 11 and Rule 21 of CPC. Question number 628. The leave may be granted by the civil court to deliver interrogatories. Option A, only to the defendant since the plaintiff is the master of the suit. B, even if they relate to the matters not in question in the suit. C, notwithstanding the objection taken by the opposite party. And D, if it considered the same necessary for disposing of the case fairly. Here a correct answer is option D, if it considers the same necessary for disposing of the case fairly. Question number 629. Interrogatories shall be answered under the CPC by way of affidavit to be filed within dash days or within such other time as the court may allow. Here correct answer is option C, that is 10 days or within such time as the court may allow. Question number 630. The court, option A, has no power to record admissions of parties at any stage of the proceedings, has power to record admissions only on issues of law, has power to record admission of parties at any stage of proceedings, and D, cannot record admission at all. Here correct answer is option C. The court has power to record admission of parties at any stage of the proceeding. Question number 631. Under Order 12 Rule 2 of CPC, the time to be given to called upon by notice is option A, 15 days from the date of service of notice, 10 days from the date of service of notice, 7 days from the date of service of notice, 21 days from the date of service of notice. Here correct answer is option C, that is 7 days from the date of service of notice. Under Order 12 Rule 2 of CPC, the time given to be called upon 7 days from the date of service of notice. Question number 632. When a party is called upon by notice to admit facts by the other party, under Order 12 Rule 4 of CPC, the party on whom the notice has been served has to admit the fact within 15 days of the notice, 15 days of the service of notice, 9 days from the service of notice, 7 days from the service of notice, 6 days from the service of notice. Here correct answer is option B, that is 9 days of the service of notice. Question number 633. Judgment on admission can be given. Here correct answer is option C, under Order 12 Rule 6 of CPC. Question number 634. Whether a defendant can file an application for disposal of the suit under Order 12 Rule 6 of the CPC. Here correct answer is option A, that is yes, defendant can file an application. Question number 635. Order 12 Rule 8 of CPC pertains to option A, notice to admit facts, notice to admit documents, notice to produce documents, both A and B. Correct answer here is option C, that is not notice to produce documents. Order 12 Rule 8 of CPC pertains to notice to produce documents. Question number 636. Which order of CPC deals with the production, impounding and return of the documents? Correct answer here is option A, that is Order 13 CPC. Question number 637. Where a plaintiff sues upon a document in his power or possession, he must produce it or a copy thereof. Option A, along with the plaint. Option B, at the time of giving evidence. Option C, at the time of framing of issues. And option D, when ordered by the court. Here correct answer is option A, that is along with the plaint. Question number 638. Framing of issues is provided by which rule of CPC? Here correct answer is option B, that is Order 14 Rule 1 of CPC. Question number 639. A court may not frame issue on the basis of allegations or contents made by the parties. Here correct answer is option C, that is in applications. Question number 640. Under CPC, issues in a suit are framed in respect of question of law, question of facts, mixed question of fact and law, all of the above. Correct answer here is option D, that is all of the above. Question of law, question of fact and mixed questions of fact and law. Question number 641. Which of the following statement is incorrect? Option A, where issues both of law and of fact arise, and if the court is of the opinion that the case may be disposed of on an issue relating to jurisdiction, it may postpone the settlement of other issues until after the issue of jurisdiction has been determined. Option B, where a suit may be disposed of on preliminary issue, the court need not to pronounce judgment on other issues settled in the case. Here it has been asked which of the following is incorrect. Option B here is incorrect, therefore it will be the right answer. Question number 642. Power to amend, issue or frame additional issues prior to the passing of a decree vests in a court by virtue of which of the provision of the CPC? Here options are Order 14 Rule 1, option B Order 14 Rule 5, C Order 14 Rule 6 and option D Section 151. Correct answer here is option B, that is Order 14 Rule 5. Question number 643. Order 15 of CPC talks about disposal of the suit at the first hearing, settlement of issues, attendance of witness, notices. Correct answer here is option A. Order 15 of CPC talks about disposal of the suit at the first hearing. Question number 644. Which order of CPC deals with the summons and attendance of witnesses? Here correct answer is option C, that is Order 16 of CPC. Question number 645. The court has the power to summon a person who is not called by any party as a witness under Order 16 Rule 8 of CPC, under Order 16 Rule 14 of CPC, under Order 16 Rule 12 of CPC and option D under Order 16 Rule 10 of CPC. Here correct answer is option B, under Order 16 Rule 14 of CPC. Court has the power to summon a person who is not called by any party as a witness. Question number 646. The list of witnesses after the settlement of issues must be filed within. Here correct answer is option A, that is 15 days. Question number 647. In a suit, the list of witnesses has to be filed by the parties. Option A, before the settlement of issues, after the settlement of issues, at any time and all of the above. Here correct answer is option B, that is after the settlement of issues. Question number 648. Prison is defined in Order 16A of the CPC includes any place which has been declared by the government or by general or special order to be subsidiary jail. B, any reformatory, Borstal institution or other institution of like nature. C, both A and B, and option D only A is correct. Here correct answer is option C, that is both A and B. Question number 649. In which condition the officer in charge of the prison may refuse to produce the prisoner for the evidence despite court order? Here options are where the prisoner is related to ruling party, where the prisoner is ex-minister, where the prisoner is government servant, and option D, where medical officer has certified prisoner is unfit to be removed. Here correct answer is option D, where medical officer has certified prisoner is unfit to be removed. In this condition, the officer in charge of the prison may refuse to produce the prisoner for evidence despite court's order. Question number 650. Under which of the following provisions of the CPC the prisoner is required to be brought to court in custody? Here correct answer is option A, that is under Order 16A and Rule 6 of CPC.